We're going to talk about the 14th Amendment and the doctrine of selective incorporation. Um, the Bill of Rights, first 10 amendments to the Constitution, the anti-federalists, those who were opposed to this new government that created a very strong central government, um, they were the ones that requested this Bill of Rights. Remember, we're asking the states to give up their sovereignty. And the people who are opposed to this new government were really concerned about the fact that we create a new constitution um, and don't have this Bill of Rights that are attached to it when all the other um, or most of the state constitutions had a Bill of Rights. And so the Federalists decide to go ahead and add a Bill of Rights after um, the new government is established. Once the Constitution is ratified, one of the very first things they do in this new government is to add a Bill of Rights, or the first 10 amendments to the Constitution. Think about this. When I say the anti-federalists are wanting to add this to the Constitution, it's because they are fearful of the federal government. They're not fearful of the state governments, they're fearful of the national government. So, when the Bill of Rights are written, they only applied to the national government, this new government that we created. It did not apply to the state governments. Now, I'm not saying the states didn't have a Bill of Rights themselves that were attached to their state constitutions, but at this time, when the Bill of Rights is written and added to and amending the Constitution, these guarantees, these protections only apply to the national government. So if a state was violating one of these rights and it was not a protection that was listed in their constitution, there was nothing that the national government could do. All right, so I cannot stress this enough, that the Bill of Rights, when written at the request of the anti-federalists because of the fear of this new national government, they did not apply to the states. The Bill of Rights only applied to the national government. Fast forward to the period of time where we have the Civil War. We have 3 amendments that we add to the Constitution as a result of the Civil War. The 13th Amendment ends slavery. The 14th Amendment, and I only have a very small excerpt from the 14th Amendment, does several things. But the only thing for this video's purposes is this portion of the 14th Amendment that says, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law." The language should look very familiar to the Fifth Amendment, because the Fifth Amendment says that, and it's once again applying only to the national government, that the national government cannot deny anyone life, liberty, or property without due process. Now, the 14th Amendment, notice the first few words. Now it's saying no state can do this. So before then, that due process clause in the Fifth Amendment only applied to the national government. Now we're adding that to the 14th Amendment. And this has been used throughout that period of time after the institution of the 14th Amendment to say, now, not only can the states not do these things, now the national government can. But what's interesting is it wasn't a situation where now the national government can't do anything that is listed in the, or excuse me, now the states can't do anything that's listed, or you're protected from the states. Let me start that over again because that got a little confusing. When the 14th Amendment was written, and now applying the Bill of Rights to the states, it's not like they all started applying right at that moment. What had to happen was someone had to challenge that in court. It had to go all the way to the Supreme Court, and the Supreme Court would now, on a case-by-case basis, start to individually apply each one of the Bill of Rights to the states. So here's a list of Supreme Court cases, and on the right-hand side is what has been now applied to the states. So I'm not going to ask you any of the court cases, and I'm not even going to ask you anything from this chart, but I definitely want you to know that it wasn't until 1961 with the court case Mapp versus Ohio that a state cannot unreasonably search and seize. Cruel and unusual punishment was not applied to the states until 1962, Robinson versus California. The right to counsel, remember that's a right to an attorney, were not protected at the state level until 1963 in Gideon versus Wainwright. And Miranda versus Arizona, self-incrimination. Most of you are probably familiar with the Miranda rights. You have the right to remain silent. That is self-incrimination. That comes from the court case Miranda versus Arizona. So that's where you get that term, the Miranda rights, or to be Mirandized, comes from that particular court case. Almost everything that is in the Bill of Rights has now been incorporated. One of the things that I find most interesting is the Second Amendment was only incorporated just a few years back in the court case McDonald versus Chicago. There are still a few things. The Third Amendment has not been incorporated. Part of the Fifth Amendment, part of the Eighth Amendment. So you are protected against cruel and unusual punishment, but excessive bails and fines has not been incorporated. So once again, just to review this, when the Constitution was written and when the Bill of Rights was written, the Bill of Rights was written at the request of the Anti-Federalists because of the fear of the new national government. They wanted the power to stay with the states. So when we write the Bill of Rights, it applies to the national government, not the states. Once again, most of the states had state constitutions and already had a Bill of Rights attached to their constitution. So the 14th Amendment, we have the Due Process Clause, which is the same as what it is in the Fifth Amendment. The Fifth Amendment's due process applies to the national government. The 14th Amendment's due process applies to the state governments and saying no state can do this. Selective incorporation is selectively, on a case-by-case basis, starting to incorporate or have the Bill of Rights apply not only to the national government, but now they have to apply to the state governments. And where you see these due process protections, the Fourth Amendment, everything that's in the Fifth Amendment, the Sixth Amendment, the Seventh Amendment, and the Eighth Amendment. So once you know those amendments, you know what your due process rights are.